Supporters of crypto assets can frequently be heard pointing out that you can't ban Bitcoin or highlighting its ability to circumvent regulations and benefit from regulatory arbitrage. But that doesn't mean that laws and the actions of major governments or regulators don't matter. In fact, their actions are extremely important, and their decisions can have long-lasting implications for this industry, both positive and negative. So let's take a look at what they were doing in 2020 and see what it might mean for the future. The SEC has spent a lot of the last couple of years mopping up after 2017's ICO bubble, and that work continued into and throughout 2020. But what made last year particularly interesting was the scale and significance of some of the projects they chose to pursue. The first major legal battle was already underway coming into the year, after the SEC sued Telegram and halted the distribution of their Gram token in October 2019, just before the intended launch of the Telegram Open Network, or TON. The SEC believed that Telegram's $1.7 billion token sale was illegal, even though it was conducted using a simple agreement for future tokens, or SAFT, a token sale framework intended to be compliant with US securities laws. SAFT use a two-step process to sell and release utility tokens. First, an accredited investor enters an agreement with a token issuer, in this case Telegram, to exchange money for the rights to tokens once the network launches. Then, once the developers have created the network and tokens are usable on it, the investors receive their share of the tokens and are free to sell them to the public. Telegram naturally did everything they could to push back against the SEC's allegations, including distancing themselves from their own project. In January 2020, they said they didn't plan on integrating a TON wallet into their encrypted messaging app when the network was launched, and would instead release a wallet as a standalone application to compete against other TON wallets. This was described as a massive blow for investors, who had largely backed the project because it had easy access to hundreds of millions of potential users. Things only got worse in March, as a federal judge sided with the SEC and blocked the distribution of Gram tokens, saying that it would violate securities laws and that Telegram had developed a scheme to maximize the amount initial purchasers would be willing to pay Telegram by creating a structure to allow these purchasers to maximize the value they would receive upon resale in public markets. This ruling was bad for the SAFT as a concept, but it was even worse for Telegram. Part of their agreement with investors meant that they had to launch TON by the end of April, or investors could request a large portion of their money back. In an attempt to prevent that, Telegram asked the court to clarify exactly what it needed to do to remain compliant with the SEC's order banning the distribution of their tokens. They hoped that the order would only apply to US investors, which would have allowed them to sell about 75% of their tokens to international investors on the condition that those weren't resold to anybody in the US. The death knell came when the judge rejected that idea, saying Telegram failed to explain how it could effectively fence off US investors or lawfully modify the sales agreement. While Telegram staggered on for a while after that decision, the writing was on the wall. On the 12th of May, Telegram founder Pavel Durov released a blog post announcing that the TON project was over, at least from Telegram's perspective. Days prior to this, a community-led fork of the project called Free TON had launched without their involvement. In his post, Durov criticised the United States' excessive influence over financial and technological developments in other countries, arguing that the US can use its control over the dollar and the global financial system to shut down any bank account or bank in the world, and that other countries do not have full sovereignty over what to allow in their territory. In June, Telegram finally ended its legal battle with the SEC by agreeing to an $18.5 million settlement, becoming one of the most significant and high-profile issuers to have fallen to the agency yet, and firmly closing the door on the very idea of the SAFT. If the death of Telegram wasn't enough for you, the SEC added one final twist to 2020's tale in December, when they filed a lawsuit not just against Ripple, the company behind the third largest crypto asset by market cap, but against two of its executives as well. The complaint alleges that Ripple has made more than $1.3 billion by selling XRP to retail investors as part of an ongoing sale since 2013, and that Ripple's CEO Brad Garlinghouse and co-founder Chris Larson orchestrated these unlawful sales and personally profited by $600 million from their unregistered sales of XRP. The complaint seems pretty damning, and we know that the SEC wouldn't take on a case it didn't expect to win. But there's obviously a long way to go before we'll know the ultimate outcome of this. Even so, the impact on XRP has already been quite significant. Following the lawsuit, the price of XRP plummeted and numerous exchanges, market makers and asset managers dropped support for the asset. After all of that, almost unbelievably, XRP is still ranked as the 5th largest crypto asset by market cap at the time of recording. So there are still billions of dollars on the line in this case, and it's certainly going to be one to watch in 2021. While Ripple has few supporters in the industry, largely because of its rather distasteful business model of dumping on retail customers, some have criticised the SEC for their actions here, viewing the lawsuit as another example of the agency interfering in the industry, hampering innovation, and harming the retail investors that they're supposed to be protecting. Undoubtedly, there are occasions when the SEC's involvement makes sense. Cracking down on obvious scams and shady ICO promoters like John McAfee seems reasonable, but preventing Abra from offering synthetic stocks to users from around the world, or clamping down on well-intentioned and functioning projects simply because they raised funds through an ICO seems questionable. Still, that's the approach they're taking, and everybody has to just deal with it. Following the SEC's victories against Kin and Salt Lending, Nick Carter noted on his On the Brink podcast that the SEC had graduated from clear cases of fraud and was now going after token issuers who simply didn't register their offerings. This new approach endangers many more projects, virtually any that issued tokens in an ICO and are still around today, and it's another clear sign that the utility token model of old is dead. It also makes you wonder just how fiercely the SEC will pursue the new generation of governance tokens. Perhaps, though, things will change before they get to them. The SEC will receive a bit of a shake-up in 2021, with various members of staff including Chairman Jay Clayton stepping down at the end of 2020. Clayton will be replaced by former CFTC head Gary Gensler, a man who truly understands cryptoassets and the technology's potential. He even taught a course about blockchain and its applications in the financial sector in 2018. From 2021 onwards, we may well see a friendlier SEC that cracks down on the worst aspects of this industry while allowing innovation to flourish. And even if we don't, many would still expect them to finally approve a Bitcoin ETF, thanks in large part to another major legal event that took place last year. On October 1st, the US Department of Justice and the Commodities Futures Trading Commission came out hard against crypto derivatives exchange BitMEX and 4 of its senior staff. The CFTC accused BitMEX, its CEO and co-founder Arthur Hayes, co-founders Ben Dello and Samuel Reed, and several related corporate entities of operating an unregistered trading platform and violating a number of CFTC rules, including failing to enforce proper KYC and AML laws. Separately, the Department of Justice filed criminal charges against Hayes, Dello, Reed, and BitMEX's first employee and head of business development, Greg Doyer, accusing them of violating the Bank's Secrecy Act. Reed was arrested and released on the same day with a $5 million bail. BitMEX's parent company HDR Global Trading Limited responded quickly and announced their intention to fight the charges, saying that they strongly disagreed with the US government's heavy-handed decisions. At the same time, BitMEX was desperately trying to convince its customers that their funds weren't in any danger. BitMEX holds all user funds on a 3 of 4 multi-signature address, where 3 of the co-founders hold 1 key each, and the 4th is a special key that signs every single transaction. Therefore, at least 2 of the co-founders must sign every transaction, which they normally do once a day at 1 PM. But if too many signers were arrested or busy evading the police, then who would approve withdrawals? To reassure customers, BitMEX started processing transactions outside of their normal withdrawal period, eventually making 6 transactions in 2 days. Altogether, between September 30th and October 3rd, more than $500 million worth of Bitcoin left the exchange. 1 week later, BitMEX announced the first portion of a significant shake-up in its leadership structure, with all 4 named defendants stepping back from executive management responsibilities. Shortly after that, the derivatives exchange hired former Revolut executive to head up its compliance department, and in December they announced a German stock exchange veteran would become their CEO starting in 2021. They'll be hoping that these appointments and other changes will help right the ship and help them make up ground that they've lost to competitors. For the industry though, BitMEX's issues may not be a bad thing. The exchange was known to have a significant influence over Bitcoin's price, but its decline as a result of both this legal battle and longer-term industry trends have reduced that influence significantly. In October, CME Group passed BitMEX on its way to becoming the 2nd largest Bitcoin futures exchange, making it quite clear that regulated marketplaces are starting to drive price discovery. This should address one of the SEC's major concerns that has prevented the approval of a Bitcoin ETF in the past. But, of course, that will be of little consolidation to BitMEX or its co-founders, who will presumably be dealing with their legal woes for quite some time. The SEC has been crypto's big bad for a while now, but it seems like the industry may be lining up for a new boss battle, this time with FinCEN. In October, the US Financial Crimes Enforcement Network claimed victory in its first case against a Bitcoin mixer, describing the business behind that mixer as an unregistered money services business that had failed to implement and maintain an effective anti-money laundering program and failed to report suspicious activities. Potentially, that victory sets FinCEN up to go after many other services designed to enhance Bitcoin's privacy, which would be concerning to many. More immediately concerning, though, was the new KYC rule proposed by FinCEN in December. The rule is essentially an attempt to apply traditional banking standards to crypto assets and will require exchanges, banks, and other intermediaries to collect and maintain detailed records of anybody involved in transactions worth more than $3,000 to unhosted wallets. The information would also have to be submitted to FinCEN if the transaction was worth more than $10,000. Many in the industry have reacted very negatively to these proposals, and for a number of reasons. For starters, the rule would massively degrade privacy, both compared to crypto assets as they function today, but also compared to any other financial tool. If you can conclusively tie an individual's identity to one of their on-chain addresses, it becomes relatively easy to trace the individual's activities throughout time. Moreover, the rule would make transactions from intermediaries like exchanges to multi-sig wallets or many DeFi protocols impossible, as you would need to provide the details of every single other person using those protocols, even though you'd have no way of knowing who they were. Most damningly, though, was the limited time given to the industry experts to analyse and comment on the proposal. Traditionally, FinCEN allows a 60-day public comment period for significant rule changes, but gave this proposal just 15 days at the height of the holiday season. Coin Center, a non-profit focused on policy issues facing crypto assets, described the move as a midnight rulemaking from a lame duck Trump administration. At the time of recording this, the window for comments came to a close with thousands of responses submitted before FinCEN decided to extend the window to the full 60 days. That means any final decision will be made by the Biden administration, who have now frozen all new and pending rules so that they can be reviewed. Hopefully, this means that the rule will be reconsidered and significantly reworked based on industry feedback. Even if FinCEN does decide to press ahead with the rule as is, there are a number of prominent organisations standing ready to fight it in court if they need to. Many of these organisations, whether it's exchanges like Coinbase and Kraken, investors like A16Z, or non-profits like Coin Center, have already put a lot of work into convincing FinCEN and Steve Mnuchin to water down their original plans, and it's important to recognise the great work that they're all doing, particularly Coin Center, to protect and represent this industry in places of power. Shortly before FinCEN unveiled their proposal, another new threat to crypto assets emerged in the form of the Stable Act, a draft bill proposed by 3 House Democrats intended to regulate stablecoin issuers. If approved, the bill would essentially force any stablecoin issuer to become a bank, and some interpretations of it would force companies offering dollar-redeemable IOUs to customers like PayPal, Venmo, and maybe even gift card issuers like Starbucks to become banks as well. And what's more, the rule would technically require every single person running an Ethereum node to become a chartered bank, or else they would be in breach of regulations by validating any stablecoin-related smart contract. This proposal would be disastrous for crypto assets, for stablecoins, and for payment technology innovation in general if it became law. Thankfully, that seems incredibly unlikely at the moment, but this proposal is a clear sign of the attention that this industry is starting to receive, and the difficulties that that attention could bring if it isn't handled correctly. Crypto assets are borderless and global, so although the decisions of rulemakers and regulators in the US are the most significant and impactful for the industry, it's also important to look at the events taking place elsewhere in the world. China is perhaps the second most significant country, and last year their government once again demonstrated its ability to suddenly and dramatically impact crypto businesses within its borders. In June, OTC desks and their customers had bank accounts frozen due to a crackdown on illegal economic activities. Then in November, executives at Huobi and OKX were detained as part of the same crackdown, forcing OKX to temporarily halt withdrawals. China's actions so far aren't believed to be related to the launch of their upcoming central bank digital currency, with the government hoping to launch it in a fairly non-disruptive way that doesn't hamper innovation. However, it's easy to imagine a clampdown if crypto assets appear to compete with the digital yuan, or indeed if crypto assets start to undermine the CCP's control in other areas. In Europe, the 5th Anti-Money Laundering Directive came into effect early in the year, forcing European crypto companies to implement strict KYC measures. Some European countries like the Netherlands chose to implement even stricter forms of the regulation, pushing companies like Deribit to move abroad to reduce the amount of user information that they would need to collect. It seems that in many European nations, just as in the US, user privacy is under threat. France, for example, introduced incredibly strict KYC requirements in December. Under the new rules, exchanges and other intermediaries will have to ask users for 2 forms of government ID and perform a full KYC process before permitting any transactions, irrespective of size. Notably, this applies to crypto transactions as well as fiat to crypto, which is where these measures would usually be applied. But it's not only privacy being clamped down on in the continent. Here in the UK, the Financial Conduct Authority banned the sale of cryptocurrency derivatives and exchange-traded notes to retail users, saying that they were ill-suited for that audience, and that there was a lack of legitimate investment need. On the other side of the world, the Supreme Court of India struck down a 2018 circular issued by the Reserve Bank of India that prevented banks from serving crypto companies, deeming it unconstitutional. When it was issued, the circular placed severe pressure on exchanges, forcing them to either shut down, change location, or drop fiat to crypto gateways. However, the industry isn't totally out of danger yet. Reports emerged in September that the Finance Ministry was seeking interministerial consultations on a crypto ban. And just before recording this, I've seen that the Indian government is moving ahead with a proposal to ban cryptocurrencies, so this is definitely a story to watch this year. On the surface, it seems like much of the year's regulatory action relating to crypto assets was fairly negative, and it's clear that things are heating up. But there were bright spots and reasons to be hopeful in the future. Back in the US, the Office of the Controller of the Currency made two major announcements in 2020. First, in July, the OCC said that national savings banks and federal savings associations could custody crypto assets on behalf of their customers. Then in September, they clarified that federally chartered banks could hold funds for fiat-backed stablecoins. These announcements were driven by Coinbase's former chief legal officer, Brian Brooks, who became the acting comptroller in May and quickly set about pushing a pro-crypto agenda. This led to some complaints, and there have even been calls for Brooks' guidance to be rescinded by the Biden administration, but we'll have to hope that doesn't happen. Even if Brooks' legacy at the OCC is undone, he's been a great indication of what a powerful pro-crypto voice can do in a short time. While he'll be moving on in 2021, Biden has appointed a number of crypto-knowledgeable individuals like Gary Gensler to powerful positions in other agencies. While I wouldn't expect any to be as pro-crypto as Brooks, it generally seems like a positive development for the industry. It's also great to see a true Bitcoiner promoted to the US Senate in the form of Wyoming's Cynthia Lummis. While she'll be something of a lone voice pushing for the industry's best treatment in the world's most powerful nation, it's definitely a step in the right direction. So that's it for this video recapping 2020. If you want to see some others in this series, I'll put links to it in the description below. Thank you so much for watching, have a great day, and I will see you in the next video.